Welcome to today's Voorhees webinar. Thank you for participating in our discussion today on bankruptcy issues for secured lenders. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your screen are multiple application widgets you can use. All the widgets are resizable and movable, so feel free to move them around to get the most out of your desktop space. If you have any questions during the webinar, you can submit them through the private Q&A widget without disturbance to the program. Tiffany and Carrie will follow up on any questions they aren't able to get to during today's presentation. If you're having technical issues, you can find answers to common technical troubles located in the Help widget at the bottom of your screen, or you can submit a question via the Q&A widget. An on-demand version of the webinar will be available shortly after the program has concluded and can be accessed using the same audience link that was sent to you earlier. Finally, as a reminder, this webinar is for general information purposes only and should not be regarded as legal advice. As always, you should contact your Voorhees attorney if you need more information or have questions about how these developments apply to your situation. And now I will turn it over to today's presenters.
Welcome, everyone. It's nice to have you here this afternoon. My name is Tiffany Cobb, and I am a partner in our Columbus office and have been practicing law for just about 27 years. And my partner, Carrie Caniglio, who will also be presenting today, is in our Cleveland office and has been practicing about 15 years. And we look forward to having a conversation, so feel free to, from a virtual standpoint, enter your questions in the inbox. We will endeavor to respond as we go along, but if we don't respond to a question, rest assured we will get back with you individually after today's webinar. So we are going to cover some basics before we delve into the topics that we are focusing on today, which are cash collateral, DIP financing, plan confirmation, and the new Subchapter V in Chapter 11 cases for small businesses. And although all of those topics really fall under Chapter 11, as you may already be aware, we thought it would be helpful to start with just a very big picture about what chapters are within a bankruptcy. And the three primary chapters are a Chapter 7 liquidation case, a Chapter 11 reorganization, and a Chapter 13 for individuals only. Again, we're going to focus today on Chapter 11's, which will be the corporate reorganization or liquidation where the company continues to operate. And by contrast, in a Chapter 7, as you may know, that's really lights out. There's a Chapter 7 trustee who comes into play and will administer assets for the benefit of creditors. Within a bankruptcy case, there is a priority scheme that is strictly adhered to and will ensure that creditors are paid really in line with this priority scheme. So you'll see at the top, the administrative expenses and secured claims are really on a parallel level. They're different, of course, if you're a secured creditor as of the petition date. You are secured to the extent of the value of collateral, which we'll get into in a minute. Administrative expenses are also to be paid at 100 cents, assuming that the case is administratively solvent. But as part of the confirmation process, administrative expenses must be paid in full, absent agreement otherwise. So that's sort of the 100-cent line. Under that, next in the priority scheme are priority unsecured claims. Those can run the gamut, but for example, can include certain employee claims. Next, we have non-priority unsecured claims, and last but not least, to the extent that unsecureds are paid in full, there can be an opportunity for equity to have value. One thing I'd like to take a little footnote and discuss is a section of the Bankruptcy Code 506A, which really is important for secure creditors outside of bankruptcy to understand. And that is, within a bankruptcy case, you are only secured to the extent that the collateral of the value of the collateral. So to the extent that the value of the collateral is insufficient to cover your full claim, the remaining amount is your deficiency claim and is treated as a general unsecured claim. And if you do sort of along these same lines, if you were to, and we'll talk about this a little bit further in a minute, if you were to get relief from the bankruptcy stay to sell collateral, and if that sale, is insufficient to cover the amount of the claim that you have, you will need to be mindful of the need to potentially amend or file a proof of claim for that deficiency amount. The filing of a petition in bankruptcy creates a bankruptcy estate that is comprised of all of the legal and equitable interests that the debtor has. That filing also operates as a stay, referred to as an automatic stay, that protects the estate, the debtor, and the debtor's property. So what does the automatic stay mean for you, and in what ways can you maybe get in trouble? The automatic stay basically provides that you can't pursue the debtor or its property as to claims or debts that arise pre-petition. With limited exceptions, the ability to effectuate a set-off is also stayed. It's important to understand that a willful violation of the stay doesn't require any malintent on the part of the creditor. It's a very easy standard for a debtor to meet. And essentially, if you have notice of the bankruptcy case, that typically is sufficient to find a willful violation if you take certain steps, again, to pursue the debtor or the debtor's property. So for you, I think it's really important to focus on the internal controls that the financial institutions, that you as a financial institution may have. So you want to make sure that those internal controls will prevent automatic letters, billing statements. You want to stop auto draws unless you're permitted to do those things in a cash collateral order, which we will be discussing here today, or in a DIP financing order. A little footnote, because it's tied to Chapter 13 cases, but there is also a co-debtor stay in a Chapter 13 case. So if there's a husband and wife, for example, and you get notice of the husband's bankruptcy filing, and the husband and wife are jointly obligated on, say, an auto loan, the stay does extend to the non-debtor spouse. Creditors can obtain relief from the automatic stay, and there are statutory grounds on which to seek that relief. So, for example, a secured creditor seeking relief from stay to foreclose on property if there is the absence of adequate protection of the collateral. We will be talking about DIP financing or debtor in possession financing, so we thought it would make sense to give you a little high level of what a debtor in possession or DIP means. Conceptually, think of this as effectively a separate legal entity as of the petition date, even though the company may have the same name. Really think of it as a different legal entity. The debtor in possession typically remains in possession of its assets, and under the bankruptcy code is viewed as the statutory equivalent of a Chapter 7 trustee. So what that means, among other things, is that the debtor in possession is to act for the benefit of creditors. So that, as stated here, the DIP is a fiduciary and owes them the highest duty of care and loyalty. Management will, again, typically stay in place and controls the case. And the debtor in possession typically will continue to operate in the ordinary course of business. And the debtor in possession repays creditors through a court-approved.
All right, thank you, Tiffany. So I'm going to take over for a little bit and talk about some specific aspects of Chapter 11. So as you may have heard, Chapter 11 is expensive. And so in addition to funding the ongoing business operations, the debtor needs to also fund the post-petition administrative expenses of the Chapter 11 case. And the debtor does this two ways. One is through use of cash collateral, or the second is through DIP financing. So what is cash collateral? Cash collateral, as you see on your screen, is defined as cash, negotiable instruments, documents of title, securities, deposit accounts, or other cash equivalents in which some creditor has a lien. So in the most basic form, let's say we have a debtor that buys inventory, takes that inventory to create a product, sells that product to a customer of the debtor, and gets an account receivable in exchange, and then ultimately collects on the account receivable to get cash. If you, as the secured lender, have a security interest in that inventory, the accounts receivable and the cash are proceeds of your collateral, they're cash collateral. So the debtor can't use your cash collateral unless you either consent to the use of cash collateral or they get an order approving the use. So one very important distinction between the use of cash collateral and DIP financing is that, as I'll explain in a minute, DIP financing is a post-petition extension of credit, so additional cash being infused into the debtor. Cash collateral is just the debtor using the existing cash and cash equivalents. And it can be ordered over your objection, provided that the debtor has offered you adequate protection. So what is adequate protection? Adequate protection is something that's really fact-specific, so it's going to depend on the facts of your particular case. But generally speaking, it's something that's required to make sure that the debtor's use of your cash collateral does not diminish your security interest as it existed as of the petition date. So it could be periodic cash payments, it could be a replacement lien, and it could just be an equity cushion. So if you have lien on real estate and there's rents from that real estate, and there's substantial equity in the property, the debtor might assert that that is adequately protecting you in the event of the use of the rents. In negotiating for this consensual use of cash collateral, you might think about asking for different types of adequate protection or additional types of adequate protection from those that we've already talked about. So for example, something that's pretty common is to ask for plan or sale milestones in your cash collateral order. So I'm thinking back, and I'm not sure I've ever seen a case where a secured lender was thrilled to be in bankruptcy. So including these sale or plan milestones are a good option for you to make sure that the debtor is keeping on track and is proceeding either towards confirmation of a plan or a sale that you may approve. And when we talk about plans in a little bit, we'll talk about the importance of, and when we talk about sales, we're talking about the importance of making sure that the documents along the way are acceptable to the lender. So generally speaking, when you include these plan or sale milestones, your include language such as, a bid procedures motion and order are filed and entered in form and substance acceptable to the secured creditor. And so we'll talk about some things that you might include in an order that would be beneficial to you. And also the timeline to make sure the debtor's not using your cash for an extended period where you're placed at a greater risk. So other provisions you might see in a cash collateral order, the main one is you're going to have a budget. And the budget is typically a 13-week cash budget where the debtor says, here's what I expect I will collect at receivables. Here's what I expect will go out the door. When you're reviewing a budget, you want to make sure that you don't see any clear items that the debtor is missing. For example, administrative expenses that the debtor may be accruing and not providing for in their budget. The U.S. trustee is going to make sure that their U.S. trustee fees are included in that budget. And when you include a budget in your cash collateral order, you want to provide some mechanism for a variation and also a requirement for the debtor to give you periodic reports. So generally, a debtor is required to file monthly operating reports. They are filed in arrears. So if I am a debtor in possession and I'm operating all of August, I won't be required to provide a report of my operations, the cash collected, expenses incurred or paid out, until September 20th. So, 20 days after the end of the month. So it's some significant period of time where the debtor could be using your cash and diminishing your position if you aren't getting these periodic reports. So the variance reports, generally speaking, are drafted in a way to provide that the debtor gives you their budget and then gives you their actual performance to that budget on a weekly basis. And once you have that, you have a more real-time analysis of whether or not your position is being diminished. Cash collateral orders generally also will include some sort of stipulations as to the amount and the validity and the priority of a secured creditor's liens. Now, these orders can get kind of complicated in terms of how the mechanisms of this work, but usually a court's not going to enter a cash collateral order that provides for these stipulations or any releases that may be contained in the order to be effective against third parties or anyone other than the debtor, unless you have some sort of a challenge period. And a challenge period is it's quite typically provided by local rule, and it's usually a 60 to 90-day period where an unsecured creditors committee, a U.S. trustee, or some other party in interest can come in and look at the creditor's liens and determine whether or not there's any basis on which to challenge the liens. And typically, your cash collateral order will have some limitations on the use of cash collateral. So, for example, let's say there's a creditors committee appointed and they've got this 60 to 90-day period to investigate your liens. Of course, you don't want them using your cash to file a lawsuit against you. And so while that is pretty customary to have a cash collateral order that prohibits the use of cash collateral to challenge your liens, courts do often require, and the U.S. trustee and creditors committee will fight for some amount of cash to be used to investigate your liens. So how much is appropriate is really fact specific. It's going to depend on the size of the case and how complicated your lien and security interests are. But I would expect if you're getting these stipulations that you're going to have to provide for a time period to have your liens investigated and some amount of cash to be used to do that investigation. The cash collateral order will also include provisions of what adequate protection you are getting. So if you're getting a replacement lien, whether you're getting periodic cash payments, whether you've got an equity cushion or otherwise. It could be an administrative claim. It could be an administrative claim that seeks priority over other administrative claims, which we'll call a super priority claim in a case. One thing with respect to replacement liens that's important to note is, we've talked about this lien that you have outside of bankruptcy in the inventory and the accounts receivable, and generally it's a continuing lien. So if the debtor buys new inventory and creates new accounts receivable, you have a continuing lien on that outside of bankruptcy. Once the debtor goes into bankruptcy, the bankruptcy code provides that your lien is cut off as to collateral that is obtained post-petition. Now, keep in mind that if, for example, the debtor had inventory that was existing as of the petition date, and then inventory is then converted into a different type of collateral, so presumably some work in product, and then the accounts receivable, the lien does continue in those assets because they're proceeds of that existing security interest. But if the debtor buys new inventory post-petition, your lien does not continue in that post-petition inventory absent a replacement lien. And I'll again caveat this to say, unless your lien is in rents, because the bankruptcy code does provide with respect to rents that your lien and security interest continues automatically post-petition unless in the equities of the case, the court decides that it shouldn't continue. Now, that's really important, in particular in a single asset real estate case, because there are quite a few cases out there that hold that a debtor, in the absence of an equity cushion, cannot adequately protect you from the use of your rents in a single asset real estate case because you already have that continuing post-petition lien in those rents. And so finally, a couple other points in a cash collateral order are you might see a surcharge waiver, and this is something that you ask for it a lot, and the extent of whether or not you get it or when you get it will depend on whether or not you're giving something to the debtor in exchange. So typically, a surcharge is where a debtor in possession or a trustee will say they can use your cash proceeds to satisfy certain administrative expenses because their use protects or preserves your security interest. So usually in exchange for getting this waiver of their right to seek a surcharge, you're required to give some sort of a carve out, and that would be a negotiated set amount for debtor expenses to pay their counsel and to pay the U.S. trustee and potentially a creditors committee if you have one, in exchange for that waiver of the surcharge argument. And then finally, your cash collateral order should include provisions of certain events that happen that will trigger a termination or a default under the cash collateral order. And again, whether or not certain terms are enforceable really depend on the jurisdiction. So some jurisdictions will permit you to give a notice to the debtor and then get automatic relief from stay, and then you'll be able to go recover against your collateral. It's pretty rare that you get that. Generally speaking, courts require at least some sort of notice period where the debtor can request an emergency hearing and demonstrate that either there isn't the default that you allege that there is, or that they should be permitted to show that they can have non-consensual use of cash collateral.
And I think just to chime in real quickly on the points that Carrie raised and maybe highlight a forward-looking, to the extent you can at the beginning of the case, and involving counsel can be very helpful for this, have this forward-looking lens to avoid legal headache down the road and legal spend frustration. So in addition to, Carrie discussing having a mechanism potentially for relief from stay, having the ability to have your claim allowed in full, having clarity in that cash collateral order as to what happens with your ability to apply remaining cash after a sale and those types of things.
So as I mentioned, DIP financing is different from cash collateral because it is now a post-petition extension of credit. So you're really, as a DIP lender, you're putting yourself in a potentially worse position by extending more cash into the debtor post-petition. So because of that, courts cannot require you, and the code specifically provides that you can't be required to provide post-petition financing. So you're not going to have DIP financing ordered against you in that absence of your consent. But DIP financing can sometimes be favorable because while you might be able to get new liens on unencumbered assets in a cash collateral order, in a DIP financing order, you may be able to get a priming lien over existing liens. So if you are the existing senior secured lender and a debtor is going into bankruptcy and they ask you for DIP financing, one thing that you and your counsel should consider is, are you at risk if someone else provides that DIP financing that the debtor will be able to prime your lien? And what that means is that the debtor would be able to show that they can adequately protect you in one of the ways that we've talked about, in granting another lender the right to come in and take priority over your first priority lien position. So you might get periodic payments. The debtor might argue that there's an equity cushion. These are things that are fact specific. So depending on how the market is or what happens in the case during the plan, you could potentially be at risk. So it's something to evaluate in whether or not you want to grant post-petition financing. All right, so once the debtor has cash to be in possession and continue operations, they're going to next look to what are they going to do? Are they going to try to reorganize? Are they going to try to sell their assets? Are they going to liquidate, or some combination of the above? So generally, you usually see plans either going to a quick sale, which we'll talk about in a bit, or you see them proceeding towards a plan. And before a debtor can get a plan approved, they have to, unless they're a small business debtor, have a disclosure statement approved. And a disclosure statement is effectively a prospectus. So it's something that big packet of paper that provides a lot of information about what the debtor's assets are, what their liabilities are, their business operations, why they filed for bankruptcy, what they're proposing to do through a plan, and include information on the risk. So it should include a liquidation analysis. It should talk about potential litigation claims the debtor may have, what the anticipated recovery on those claims are, and it should explain to creditors why the debtor believes that the plan is a better option than having the case converted to Chapter 7 and liquidated. Once the debtor has had a disclosure statement approved as providing adequate information, the debtor will then solicit the disclosure statement to creditors to vote on approval of a plan. So what is a plan? A plan can do a lot of things. A plan can provide, as I said, for the reorganization of a debtor, which is, I think, typically what we think of when we think of a Chapter 11, where the debtor will perhaps get new financing or may solicit the equity interests for new investments and try to fund a new reorganized entity to go forward outside of bankruptcy. A plan might also provide for the sale of the assets, and it can also provide for a liquidation. And generally speaking, the plan requires classes of creditors to be divided up and explain what the treatment of those creditors are, and all impaired creditors have the right to vote on a plan. So what that means is if you're in a class of creditors where you're deemed to be unimpaired, you don't get to vote, you're deemed to have accepted. But impairment is a pretty low standard. So it's if any of your legal rights are altered, you're impaired. So this could be a change in the timing of your payments. It could be a change in the interest rate. It could be anything that gives you something different or less than what you were contractually obligated to receive. Now, one thing that's very important to keep in mind here is impairment is determined from how the plan treats you. So earlier, Tiffany mentioned how the bankruptcy code can provide for bifurcation of a claim between the secured portion and the unsecured portion. There are also different provisions of the plan, the code that provide for different treatment to creditors. So for example, landlords may have, say, a 30-year lease where, ordinarily outside of bankruptcy, if you default, you owe them for 30 years of rent, which is excessive. So the bankruptcy code has provisions limiting that. The case law says that if the impairment or the different treatment is based on the code, you're not impaired under the plan. But if it's the plan that's providing you with different legal rights, then you're impaired for voting purposes. So with respect to secured creditors, at a minimum, the plan has to provide that you keep your lien and you get deferred cash payments that are equal to the value of your collateral, or you get the proceeds of your collateral. So again, a plan then may provide for what's called lien stripping, where your lien is treated as secured to the extent of the value of your collateral, which the debtor would have to demonstrate at the confirmation hearing, and then unsecured as to any remaining balance. So now once the debtor has solicited this disclosure statement and provided you with a copy of the plan, ballots go out and creditors get to vote on the plan. And if at least 1/2 of the creditors and of the number of creditors and 2/3 of the value or dollar value of creditors in a particular class vote in favor of the plan, that class is deemed to accept. If all of the classes accept, if all of the impaired classes accept, then you've got this consensual plan. But a plan can be confirmed over the objection of creditors or a class of creditors in what's called a cram down. So now, generally speaking, a plan can be crammed down so long as the plan does not unfairly discriminate against these rejecting classes. And that effectively means that creditors of the same type need to be treated in the same way unless there's a reason why they're different and should thus be treated differently. And the absolute priority must be satisfied. So what that means is junior classes can't get paid until the prior classes are paid in full. And the plan must also be fair and equitable with respect to each class of claims. And so it's different if you're unsecured or secured, but with respect to secured creditors, again, you need to keep your claim or keep your lien and get payment stream equal to the present value of your collateral. And generally speaking, plans must also, whether it's crammed down or consensually confirmed, need to be provided in good faith. They can't include provisions that are prohibited by law. Must provide creditors with at least the liquidation value of their assets. All priority creditors, as Tiffany had mentioned earlier, so all administrative expenses, tax claims have to be provided for full payment under the plan. And I should caveat that tax claims, to the extent that they're entitled to priority treatment, as there are some tax claims that are unsecured, they need to be paid in full at confirmation or under the plan unless the creditor agrees otherwise. And the plan must be feasible. And effectively, this just means that it's not likely that the debtor is going to fail in the plan and end up back in a Chapter 7 case or otherwise. Once a plan is confirmed, if it's a reorganizing plan, the debtor will receive in Chapter 11 a discharge of any debt that arose before the date of confirmation. So note, this is different than, I'll mention this on another slide, I'll just say it now. It's different than in Chapter 7, where the discharge is effective only for claims that arose through the petition date. But again, Tiffany had already explained this, that all administrative expenses of a Chapter 11 case have to be paid in full at confirmation. So really the timing of the discharge really shouldn't, in a reorganization case, shouldn't be much different for those administrative creditors. And also, if the debtor is liquidating through Chapter 11, they're not going to get a discharge. And then once this confirmation order is entered, the plan is effectively a new contractual obligation between the creditors and this post-petition entity.
And it's really important to review the plan, disclosure statement, and ballot very closely in general, but also specifically, I wanted to highlight the release and exculpation provisions. It runs the gamut across the various circuit courts as to what is permissible to bind parties in interest to certain broad releases. Some courts require an affirmative opt-in by the party in interest who is voting to agree to a release of a non-debtor, for example. Other courts just have if you're silent, you're deemed to accept. So it's really important to have the thorough review, have counsel involvement. Just to give one example, suppose there is a non-debtor guarantor against whom you believe you have full rights to pursue any deficiency. Well, you may not, because the plan may provide for a broad release of that non-debtor entity. On the flip side, so that guarantor release is one that you want to be alert to. On the flip side, as a lender, you may have an ability yourself to obtain a broad release. And so, perhaps you can structure through your negotiations with the interested parties, the plan proponents, if you will, an opportunity to have a broad release as to you. And that release could be broader than what may be contained in a cash collateral or debt financing order.
So generally speaking, with respect to the debtor, the discharge is a release from personal liability for certain debts. It does not release the lien unless there was a lien stripping, like we've talked about, or there's a sale that we'll talk about in a minute. And the discharge operates as an injunction from prohibiting a debtor from pre-petition debts. So just in a really basic example, let's say you've got a lien on real estate that's owned by a debtor, and the debtor receives a discharge. Post-petition, if you sell, let's say you get a foreclosure order and you sell that property, and the proceeds of the sale are not sufficient to satisfy your lien in full, the discharge will keep you from being able to pursue the debtor from any deficiency judgment. And as Tiffany mentioned, this concept of releases to third parties, one reason why it might be really important to pay attention to those releases, if you have a guarantor or some other party who is jointly liable, whether or not you can pursue that party for the deficiency will depend on what your loan documents say and whether or not there was a broader release under the confirmation order. And already mentioned this, Chapter 7, the discharge is through of debts through the petition date. Order for relief is generally the petition date. And then in Chapter 11, it's debts that arose prior to the confirmation. All right, so now we've talked about debtors proceeding through a plan. Another option, which is perhaps the more common option, is for debtors to pursue a sale through bankruptcy.
So 363, Section 363 of the Bankruptcy Code addresses sales generally and also free and clear sales specifically. Just as at a high level, the Section 363 sale process will include or should include as robust marketing by the debtor as can evidence that there is a fair and arm's length opportunity to bid on assets to ensure that the highest and best bid is ultimately secured, because of course in a bankruptcy, unlike outside of bankruptcy, the goal is really to maximize what comes into the estate. So there is that marketing aspect at the beginning. Sometimes that marketing happens extensively pre-petition, and sometimes in what are called first day filings, first day motions, and accompanying declarations, there will be reference to robust marketing of the debtor's assets. Sometimes that marketing happens post-petition. But depending upon the complexity of the case, you may have not only financial advisors who are retained for the debtor, but also investment bankers. And so this marketing is really, important. Sometimes, but not always, there will be what's called a stalking horse bidder. If you're not familiar with that term of art, it essentially is the baseline. This is the first bidder, and we're going to disclose this to everybody and say, this is what, ABC company is willing to pay for the debtor's assets. Here's the asset purchase agreement under which that stalking horse bidder is willing to proceed. And it sets that floor against which there is hopefully going to be, or the intent within the bankruptcy setting is, of course, to maximize value and have competing bids. There are breakup fees and the like to incentivize a third party, this ABC company, to be the stalking horse bidder. But again, not all cases have a stalking horse bidder. The there is a marketing effort and a procedures path to obtain interested bids with the asset purchase agreements at that point. But again, it can be ideal to have a stalking horse bidder to the extent that there is an interested third party to fit in that role. So you have marketing, you may or may not have a stalking horse bidder with an asset purchase agreement, but you will very typically see motions earlier on in the case that will be what we call bid procedures motions or sale procedures motions that will align with the milestones Carrie mentioned that might be in your cash collateral or debtor in possession financing orders that will say, by this date, an interested party can submit qualified bid. Here's what a qualified bid entails. And then if there are competing bids, there will be some sort of, filing to say, this is what we've selected as the top bid, or there will be an auction process. And at that auction, sometimes the stalking horse bidder may be outbid, for example. And then subsequent to that auction, to the extent there is one, there is then the sale hearing and the entry of the sale order. To the extent that you are, and it depends, in not all courts will permit this, but if you are a secured creditor, you want to be alert to your right to potentially credit bid to protect your interests. So make sure that you understand the timing and the procedures for credit bidding, which is a right you really want to preserve to auction. To give you a little flavor of the auction process, typically and admittedly, the last auction I attended was an in-person one. I know Carrie attended one via Zoom, but essentially it's done on the record. The competing bids the bidders are literally put on the record to bid back and forth. And sometimes in complex cases, there will be subsets of assets that are maybe in different lots, and there's an attempt to see, are we going to do better in toto having this bucket of assets, this bucket of assets, and this bucket of assets sold separately when you combine those numbers, and then you see what those numbers are, and then you may go to the bidders who want to bid the whole enchilada, and you see where that leads you. It's typically attended by the bidder, their counsel, obviously representatives for the lenders and for the debtors and the creditors committee, and so it can often be quite a large conference table worth of folks. And if you consider at your cash collateral order stage how you can get cash after a sale, and I think we talked about this earlier when we were talking about the cash collateral setting to think ahead. So now we're ahead and we're thinking back. Did you have in your cash collateral order language that will kind of alleviate a headache? Or, will you otherwise have some sort of fight with the Chapter 7 trustee if subsequent to the sale, there's, say, a quick conversion to a 7?
So a couple, I guess, sort of considerations on this looking forward that I want to talk about is, in the bid procedures, we're talking about credit bidding rights a little bit more in depth in a little bit, but generally speaking, if you're a traditional lender, you're using credit bid rights to be protective and make sure that what you're getting in the sale is something that is acceptable to you. So in your bid procedures, again, reason to make sure that you're requiring that they be in form and substance to you, you can provide that, for example, you're deemed a qualified bidder, so you can attend the auction and bid. You establish the timing for submitting that bid, and Tiffany did briefly mention this. You don't want to have to make that credit bid until the auction, right? Because you want to see who the bids are or the bidders are and what their bids are. And if the lowest bid or there's a bid that's the highest bid at that point that's acceptable to you, then maybe there's no reason for you to credit bid, because if you're credit bidding, you're running the risk that you may in fact take an operating business if it's a going concern sale. And for most traditional lenders, I don't think that's something they're in the business of doing. But one horror story I want to share is I was recently involved in a case where we did have a very lengthy virtual auction. And in that case, the debtor had entered into a stalking horse that we, as the secured lender, did not approve. And the stalking horse's asset purchase agreement included a provision that was very problematic for the lender. It included effectively a hope note. So it was a provision that for 10 years, the debtor would, or the successful bidder would pay out a percentage of its profits after payment of certain other things that were really broadly defined to mean effectively you're probably getting nothing, and would require you to keep this open for 10 years to see what the payment stream was going to look like. So we objected strenuously to this provision, to the designation of this stalking horse as the stalking horse bidder. And unfortunately, we were in a very debtor-friendly jurisdiction where the court effectively said, you've got a credit bid right, so I'm entering this over your objection. So when we went into the auction, because we had this asset purchase agreement for the stalking horse that was setting the floor, every other bidder was using that unacceptable asset purchase agreement as the basis for their bid. So we were 8 hours into an auction where we were continually being forced to credit bid, because that was the only way we were able to get the parties to a point where they took that particular piece of consideration out of their asset purchase agreement and then began to bid on terms that were acceptable to the lender. So now going into a sale, you might say, okay, well, what happens to my liens? Well, liens generally attach, and the sale order will provide for this, to the sale proceeds to the same extent, validity, and priority as they had prior to the assets being sold. So what if the proceeds aren't enough to satisfy you? That's your biggest concern as a secured lender in bankruptcy. So the bankruptcy code, it's section 363F, provides 5 instances in which a debtor can sell assets free and clear of liens. The first one is non-bankruptcy law permits that sale free and clear. The second one is that you as the lender consent. The third one is the sale price exceeds the amount of all the liens on the property. Fourth, if the security interests are in bona fide dispute. And 5, if the entity could be compelled in a legal or equitable proceeding to accept cash in exchange for the lien. So generally, the majority of courts say that a debtor cannot sell free and clear of a secured creditor's lien in the absence of consent unless the sale proceeds are sufficient to satisfy the liens. But there are a minority of courts that look to that Section 506 and say, well, the sale establishes the market, and the market value for your liens is whatever the sale proceeds are. So that is what you get, and then the sale is otherwise free and clear of your liens. So certainly as a secured lender, that's problematic. And those minority of courts that do take that position say, well, your credit bid rights are what protect you from that situation. So what is a credit bid? A credit bid is it's permitting a creditor to offset their lien and their debt against the amount that they would be bidding for the purchase of the assets. So we provide this example that says that loan to own holds a blanket all asset lien securing a $10 million debt against the debtor ABC Inc. And loan to own prevails at an auction with a $12 million bid. So that would be structured with a $10 million credit bid amount towards its debt and then $2 million in cash. Now, again, if you're a traditional lender, once you get to that $10 million, presumably you're not going to be credit bidding any further because, assuming you don't want to take control of an operating business. So now Section 363K of the Bankruptcy Code does automatically provide for credit bidding rights. So again, we've talked about having your bid procedures be acceptable to you. You do automatically have a right to credit bid, whether the procedures provide for it or not, unless the court orders otherwise. So a debtor can move to prohibit or limit a creditor's right to credit bid. And generally speaking, the vast majority of courts have said that this cause to limit a credit bidding right is generally only applicable in situations where a secured creditor has engaged in some bad misconduct. So it's colluding in the sale process or something that's otherwise prohibited, right? So an argument that, well, the amount of the debt is so high that it's going to chill bidding is generally not sufficient to limit a secured creditor's rights to credit bid. But there was a case out of Delaware in 2014 that really caused a lot of fear with secured lenders because in that provision we had, or in that case, it was Fisker Auto Holdings. You had a creditor that had bought a $169 million claim for only $25 million. So they pay $25 million and then take the position of a previous lender that was owed $169 million. And in that case, the court said, well, there was cause to limit the secured creditor's credit bidding rights to the $25 million purchase price it had paid for the debt. So on the face, that sounds very scary. But I will say, in that case, it wasn't just the fear of chilling credit bidding that was an issue, and also realizing there's a pretty substantial difference between $169 million and $25 million. That probably the greater issue was that unsecured creditors had challenged that secured creditor's security interest. So they were challenging the extent and the validity of the lien. So I think that was probably a greater issue for the court in determining why there was cause to limit the bid. But of course, it's always a concern going into a case that you should evaluate with your counsel. All right, so we don't have a lot of time left, so I'll just very briefly go through this Small Business Reorganization Act for this creation of the new Subchapter V bankruptcies. So what is Subchapter V? So Subchapter V is it's a more streamlined Chapter 11 process. It's available only for small business debtors. And it's really kind of a hybrid between Chapter 7 and Chapter 11. It's less expensive, it's more streamlined, and it's faster than a traditional Chapter 11 case. You won't have a creditors committee appointed, which is great news for secured lenders since they're generally the ones that we're disputing liens with. There's quicker deadlines to get a plan proposed, and there's no payment of quarterly fees to to the U.S. trustee. Subchapter 5 is only on the face of it available to businesses or entities with non-contingent liquidated debts of $2.7 million or less, and at least 50% of which has to be commercial or business debt. But the CARES Act, as a result of the pandemic, has increased that debt limit to $7.5 million. So a substantially greater amount of businesses are available to seek relief under Subchapter 5 now than they otherwise would be able to. I mean, again, we mentioned the single asset real estate cases briefly previously. They're not eligible to seek relief under Subchapter 5. In order to elect Subchapter 5 status, a debtor needs to check a box on their petition that they file with the court. There's a dispute of whether or not a debtor may amend their petition either to seek Subchapter 5 status or not seek Subchapter 5 status, and if so, what the time period is to do that. So it really is going to depend on where your case is pending. But once they make the election, a debtor is required to file a most recent balance sheet, a statement of operations, cash flow statement, and federal income tax return. They're also required to continue to file operating reports as a Chapter 11 trustee or Chapter 11 debtor in possession normally would do. And that would include effectively actual and projected cash receipts and disbursements. Again, no obligation to pay U.S. trustee fees. And importantly, while electing Subchapter 5, and although there is a trustee appointed that we'll talk about in a second here, the debtor retains possession and control of its assets and business operations. So Tiffany mentioned briefly in Chapter 7, you have a panel trustee that's automatically appointed. That Chapter 7 trustee is not permitted to operate the debtor's business unless it obtains an order permitting it to do so, which is pretty rare in Chapter 7. And that panel trustee takes possession of the debtor's assets, liquidates them for the benefit of creditors. In Chapter 11, you don't have a trustee other than the United States trustee unless there's some sort of fraud or mismanagement or other bad acts that just satisfy cause for appointment of this Chapter 11 trustee that then takes possession and control and operates the debtor's business. A Subchapter 5 trustee is distinctly different from both of those trustees. The Subchapter 5 trustee does not take possession or control. It really more acts as a mediator to facilitate a confirmation of a consensual plan. The Subchapter 5 trustee does have the ability to investigate the debtor's assets and liabilities and make recommendations to the court as part of the confirmation process. And the Subchapter 5 trustee may ultimately be appointed to administer payments to creditors under a plan similarly to as is done in a Chapter 12 or Chapter 13 case. There are a couple of differences with plans as to Subchapter 5 trustees. The first is that the debtor must file a plan within 90 days, and it's pretty uniform. Must means must. So there are courts that say if the debtor failed to do so and either didn't seek extension of that time prior to its expiration or is unable to show excusable neglect, that there may be grounds to dismiss the case. And so for that reason, what the thought of whether or not a debtor can amend the petition becomes pretty important, because if you're a debtor and you miss that deadline, you can't show excusable neglect. Really, the only thing you can do to avoid dismissal would be to amend your petition and unelect that Subchapter 5 treatment. But again, something to keep in mind is, this 90-day deadline to file a plan is only to file a plan. So if the debtor files an incomplete or otherwise unacceptable plan, once they've filed it, they've satisfied that timing requirement, and then they have as much time as they can get otherwise to modify and try to get a consensual plan confirmed. The one thing that's important to note as well, we talked about approval of a disclosure statement in a Subchapter 5 case. There's no requirement for the debtor to get approval of a disclosure statement prior to soliciting for vote. So really, they just have to file what we would call a combined plan and disclosure statement, where the plan includes the business information, liquidation analysis, projections, and all of the things that you would see in a disclosure statement in a more condensed form in the plan itself. A Subchapter 5 plan can be confirmed with consent without the need to have any impaired accepting classes. Cram down for unsecured creditors is a little bit different. So we talked about a plan being fair and equitable, not discriminating unfairly, satisfying the absolute priority rule when we're talking about a traditional Chapter 11. But in Subchapter 5, as to unsecured creditors, the plan just has to propose to pay the projected disposable income for the first 3 or 5 years of the plan. And if the plan proposes that, equity can retain their equity interest in the debtor, which is drastically different than is in traditional Chapter 11. Secured creditors, you're treated the same. You get to keep your lien, and you get the deferred payments equal to the value of your collateral. And then the discharge would either be entered upon confirmation of the plan, or if the plan is providing for these payments over 3 to 5 years, it's entered when the payments are done.
So with some rapid fire, I will run through a few things under the avoidance action topic, which is a little beyond the scope of our presentation anyway, but we thought we would throw this in for some additional thought and help. As you may know, there are avoidance claims under Chapter 5 of the Bankruptcy Code, and avoidance being kind of the generic term, and there are different sections that have different statutory elements of a claim. The most typical claims are preference claims for transfers that are made by the debtor within 90 days of the petition date. And then fraudulent transfer claims, which I think people sort of pause and think, well, I didn't commit fraud. It's not fraud as to the transferee. It's number one, it can be an intentional fraud by the debtor, an intent to hinder, delay, or defraud creditors, a transfer made that can reach back under the Bankruptcy Code 2 years, and under state law, Ohio being 4, can be a very big net that's cast, and funds that are sought to be avoided and recovered. But that's the intentional fraud, again, as to the debtor's intent to hinder, delay, and defraud, not as to you, the recipient. But constructive fraud is also a common claim, and that really only requires that there's a transfer that's made without reasonably equivalent value. So just think of, there are so many examples I could give you where very sophisticated clients have been trapped in, arduous litigation over this reasonably equivalent value notion, particularly when you have a complex debtors with affiliates, and where perhaps one debtor entity is paying on account of another debtor. So it is perhaps a topic for a full hour. We could spend another time, but I just wanted to, again, just kind of give a high level picture of the types of claims that can occur within a bankruptcy case. Most avoidance claims don't have to be brought for 2 years from the petition date, so you have that risk for a pretty long period of time. Under the preference claims, I want to spend just a few minutes talking about a defense, a risk first, and then a defense that I think is more germane to financial institutions. If you have a floating lien on inventory and accounts, the attachment of that lien is a transfer for purposes of a preference claim risk. So having that ongoing attachment during that 90-day period does expose the creditor to avoidance risk. So, of course, that probably surprises some of you on the call today, that during that 90-day period, as new inventory, new receivables are created, and you have the floating lien continually attaching, there is a risk. But there's a defense, and it's commonly referred to as the improvement in position defense. And essentially, that's going to look at that whole 90-day timeline and see the extent to which you enhanced or improved your secured position. And it's only the amount by which you improved your secured position that would be subject to clawback. So, for example, if on the 90th day you were owed $2 million and the totality of the collateral, including the accounts and inventory, is valued at $1.5 million, you're undersecured to the tune of $500,000. And then through the 90-day period, suppose new inventory and receivables are created to now bring you fully secured as of the petition date. It's that amount, that $500,000 by which you've improved your position, that is subject to potential clawback. I should add that it's not only this enhancement in your secured position that's looked at, but also whether there's prejudice to creditors, and that there is a lack of clarity among the courts and in the case law as to what that means. And I just mention it to the extent that you're viewing yourself as a fully secured creditor with no preference risk. That can be an issue, but there is this improvement in position standard to protect you. And with that, I think we recognize there are several questions that We will need to circle back individually with those who took the time, and thank you for raising questions. We hope that you have learned something new today and that we will have an opportunity to work with some of you in the future. So thank you so much for attending.